Alex here with a perspectives video on balancing the bench. We are here with Jasmin Lilly-Spells, Chief Deputy Public Defender and candidate for Department 23 of the 8th Judicial District Court. We are here with Jasmin Lilly-Spells. Why don't you start off with you and your campaign for Department 23 of the 8th Judicial District Court?
Thank you so much, our Nevada judges, for allowing me the opportunity to speak with you and share information about my candidacy. My name is Jasmin Lilly-Spells. I am a candidate for Department 23. When I was a young child, I didn't know any attorneys and I never thought about a career in law. When I was approximately 16 years old, my favorite cousin was tragically killed. This was right around Christmas time as all of our families are preparing to celebrate the holiday. The tree is up, holiday music is playing, and we get a knock at our door regarding an unidentified body. So I went to law school to begin to help others. And for over a decade, I've been protecting the constitutional rights of all and giving a voice to the voiceless. I've worked alongside victims, community partners, business members, family members, and defendants to reach great case resolutions. And I've worked along an upstanding police force. At home, I am the wife to a Navy veteran. I'm the mom of four children, ages 11, 9, 5, and 2. I understand how judges' decisions are very important, how those decisions are long lasting, because my cousin's death and the circumstances surrounding it has affected me for over 2 decades. I also understand how the law affects everyday people and small business owners. And that is why in my courtroom, I promise to provide equal access to justice, a listening ear, and balanced rulings based upon the law. I am asking for your support for District Court Department 23. Thank you.
Thank you so much. So we're going to go into the first question now. This one's on the public defender surge. There was an article out on this a couple of days ago, and I actually heard about it prior from public defender Belinda Harris. What makes it unique or special? Because I don't think the public really understands why it's a big deal.
Thank you for that question. So typically we have a set person or set type of person that runs for office, either being a Las Vegas name where their family has been here for decades upon decades, and you see a generational cycle where their father or grandfather, uncle, etc., are judges in the community, mayors, things like that. And then we see district attorneys run. The public defenders rarely run for a number of reasons. The first one being money. It's very expensive to run a campaign. So for so many public defenders to be taking this on, I think is monumental and historical. Additionally, typically people do not like the sight of public defense because they don't understand exactly what we do. And they think that our job is to allow criminals to go free or in some aspects to make our communities less safe. That can be the furthest from the truth. And so I think that prevents a lot of public defenders from running, but I am happy to say that this year we have a record number of public defenders running, and the entire aspect of it is historical. This state has never had African Americans actually run for election first. We've had appointments and then retention elections and re-election. However, no one who has been Black has just ran immediately and been elected by the public. So this is a historical year, not just because of COVID, but because of all of those reasons.
Mm-hmm. I actually do get questions from the public asking why so many prosecutors run, and I never really knew how to answer that question. And I do know that also, it seems to me that the negative perspective on public defenders, at least when it comes to people who view our videos, it seems to not be as strong when people are actually able to see them in action, like in the courtroom doing their job, as opposed to
Mhm.
reading something in an article. So sometimes I think it helps the public to actually see you guys doing your job. They get a different sort of perspective. Going into our next question on changes in cash bail, apparently there was a publication by the Supreme Court of Nevada on this issue, and it seems to me from what I have read in some of the articles that it is a colossal change to how cash bail is being handled. Do you have any insight on that, or do you have any details that you can provide the viewers with?
Thank you very much for that question. Recently, two attorneys from our office had a huge victory in the case of Valdez Jimenez. And previously, individuals who may have been stopped on a traffic offense, may have been stopped for a small amount of drugs. If they were poor and indigent and could not afford bail, then they would remain in custody prior to conviction, prior to anyone determining that these people had committed a crime and were guilty just after an arrest. Now, the state has to prove that there are no means that will leave the community safe and will ensure the person's return to court for bail to be given. So we have to now look at whether someone can be released on an own recognizance or whether someone can be released on electronic monitoring. This is significant to all of us because the taxpayers pay approximately over $120 per day per individual who is in jail. And so when we have people who are in custody before conviction simply because they cannot afford cash bail, it's a disparity between those who are extremely well off and those who are just making ends meet. And additionally, it is an additional cost to our taxpayers. So especially post COVID 19, where our state is going to be looking for ways to move forward and ensure that our economy can be vibrant and people have employment and our schools can be funded and things like that. This is going to be huge for the community that we can lower the cost in that arena.
Okay, one of the things, you might find this funny, but a lot of our viewers are child custody and divorce savvy. And one of the things that they noticed was a requirement that family judges enter findings, specific findings of fact in support of some of the custody decisions that they make. And we noticed that one of the changes to, I guess, cash bail and part of the publication from the Supreme Court was that specific findings of fact were now going to be needed, I guess, in your area. And how much of a game changer is that, or what impact that's going to have on decisions going forward?
I think when a judge is required to make specific findings of fact, it is a huge game changer for a number of reasons. We have different tiers of courts. And so when a case moves up through the system, there may be a different level of judge looking at the same case or the same issue. And now, with the requirement that there are specific findings of facts made, it is easier for the next judge to determine and understand why the prior judge made a specific ruling and whether the prior judge made a ruling based upon the law or based upon their own affinity bias or another bias or another factor that should not have been relevant in the case. So I think this moves us forward to more equitable decisions and more streamlined decisions, but definitely towards judges following the law and not making those gut decisions and basing their decisions upon factors that should not be considered.
Yeah. So the next question goes into discretion. This ends up coming up all the time, and not so much in criminal law, but now that you're here, I guess we could ask you this question. My understanding is that you have to deal with wide latitude as far as discretion going into sentencing determinations. How have you struggled with that type of leeway given to the judiciary? And I don't know, go into any specifics you'd like to.
I recognize the discretion, and it can be both a good thing and a bad thing. In the federal system, they have more determinate sentencing and it's based upon a point system. But that necessarily does not allow for all mitigating circumstances to be taken into account, and vice versa, all aggravating circumstances to be taken into account. And I think that sometimes things are not just as black and white as they seem. And so person specific facts need to be taken into consideration, whether they are the getaway driver or someone who assists after the fact should not necessarily be punished to the same extent as someone who committed the crime. For example, if someone goes in and commits a bank robbery and they're in the bank interacting with the person, maybe have a gun or what have you, and then someone later drives that individual to another place or happens to be their getaway driver but is unarmed, our law treats them equally. And I think that there's a huge difference as to the level of planning and the level of involvement. And the discretion allows a judge to take that into consideration. And that can be a good thing. But it can also be a bad thing because we are all humans. We all have our personal thoughts. Everyone has affinity biases, which are those subconscious or unconscious biases or things that you don't like. And if you're not aware of those things, then it could end up that two people who are similarly situated as far as priors, as far as the crime that they committed, you find a huge disparity in their sentences. And we've seen that a lot in certain courtrooms. And I think that that's important because it is important that people are treated very similarly when they have similar backgrounds, similar criminal history, and similar charges.
I love that answer. It's probably the best answer we've gotten on discretion so far. Especially, I mean, the part that I've always brought up is you'll see the bias bleed through where the court has discretion, but you also brought up the good side of it, and that's really cool. Going into right to a speedy trial. So the two questions that I get on this is, number one, a lot of the viewers are wondering why it's waived so often or routinely. And number two, apparently an attorney can waive their client's right to a speedy trial without even really getting permission from the client. I'm not sure if that's true, but go ahead and go into those two issues if you'd like.
Thank you very much for that question. The right to a speedy trial is both a United States constitutional right, but additionally, Nevada has codified that as well. And we specify it a little bit more. For criminal cases, an individual has a right to a speedy trial within 60 days from their district court arraignment. And that can be a very quick turnaround depending on the type of case that you're handling. If you're handling a murder case, you may not have all of the discovery, video surveillance, written statements, transcripts of audio recorded statements within that 60 days. Our Metropolitan Police Department sometimes has a backlog of fingerprint examinations, blood examinations, DNA. And so you may not have those things. And oftentimes we would waive the right to a speedy trial. We would also look at getting additional discovery in order to speak to witnesses, alibi witnesses, or other individuals who can either assist in mitigating circumstances or if they are going to assist the other party's side. We want to know those things so that we can anticipate it. We don't ever want to be in trial and something comes up that you're not prepared for. So you need to very thoroughly investigate all aspects of the case. And that's sometimes why we waive that right to a speedy trial. In the criminal arena, we do have to have the client permission to waive the right to a speedy trial, and a judge will specifically. Now, typically what our rule and practice is that if someone is in custody, we have them invoke their right to a speedy trial because there's a liberty interest at stake. If someone is out of custody, typically we ask them to waive the right to a speedy trial. And that is also a factor of public defenders have hundreds of cases. We typically have anywhere between 100 to 300 cases that we are dealing with on a daily basis. And we do an excellent job at case management. But you can imagine there are times when I have 10 to 15 cases set for trial. And if everyone was a 60-day turnaround, it would be impossible for my investigator, who services 7 attorneys, to reach everyone, and impossible for me to get all of the motion work done within a timely manner and ensure that I'm giving quality, effective representation to each client.
Mhm. So the next question, it can come off as a little generic, but I'm also going to add something that I've noticed to make it a little bit more fun, I think. The generic part of it is, what is the difference between private counsel and a public defender? And the thing that I've observed is we're covering a multitude of cases right now. And one of them, actually two of them, involve brothers. One of them is in his own, they're both in their own separate case. And one brother has a public defender, one brother has a private attorney. And one of the things that we're noticing as we cover these cases is that the brother with the public defender, not as many hearings for us to go and record. The brother with the private attorney, there's hearings all the time. We find ourselves scrambling to get to that courtroom. It's like absolutely nuts, the disparate difference. And we actually get questions from the viewers, when are you going to cover this guy? And we're like, there's no hearings. So I'm sorry to
Oh
laugh, but it's just like we never thought that that would happen, but we're starting to notice the difference right there, just because how often we're in one courtroom and how not in the other. Anyway,
no.
go ahead and
Mhm.
talk about it a little bit. I think it'll make your answer a little bit more fun too. Go ahead.
That particular fact pattern does not make me extremely happy. But so there are a couple of differences. The public defender's office, our mission is to represent individuals who cannot afford their own attorney. We have to be appointed by the court versus a private attorney who is often picked and paid for by an individual. So if you want to research and decide exactly who your attorney will be, then you do need to go the private route, because within our office, our cases are randomly assigned. Now, there are some times where the Office of the Public Defender has a conflict, meaning we have represented a witness, a victim, or a co defendant in a case, and we ask the court to appoint a private attorney to service that client. In that arena, that individual would have a private attorney, but they would be appointed by the court. So they still would not be responsible for paying that attorney, but they also would not be able to pick which private attorney they have as an attorney. Now, our office is really one of the best defense offices in the country, and we have an amazing staff. We are not just over 100 attorneys, we have secretaries who assist us, we have on staff investigators. So, whenever we need something additional, we don't have to ask the court for money or try to hire a private investigator. They're are already employed by our office and they are consistently working on a daily basis. We also have staff social workers, and that allows us to quickly identify mental health issues, gambling issues, addiction issues, and apply to those diversionary courts. And because we have a working staff of social workers, we have a working relationship with these courts and a working relationship with the community resources that offer these services. With regard to Las Vegas Rescue Mission or Salvation Army, when you have a private attorney, that private attorney may or may not have a investigator. It will be very unlikely for them to have a social worker. Now, sometimes they may be able to hire one if you have the money for it, or in certain aspects, they can ask the court to pay for it or the taxpayers to pay for it. But it's not as streamlined as with our office. So I would like to say in our office, you get kind of the full service package with a defense attorney. Now, with regard to additional hearings, each attorney, whether private or public defender, should be as qualified. And if there's motion work to be done, investigation work to be done, mitigation work to be done, social work to be done, that should be done by your attorney, no matter whom you hire. But sometimes the difference is a public defender will analyze your case and look at it and say, okay, these are the legal aspects of the case that I am fighting, and this is what we're going to work on. A private attorney may look at your case and say, I can do these things, but you're paying for each of these things. Now, that's not to say that a private attorney is going to rope someone in to have them pay for things that are unnecessary on the case, but in all professions, you have good, bad, and in the middle. So it's also not to say that that never happens. So that's the main difference between the two.
Okay, it was great. I think it was a great answer. Appreciate it. Last question, and this one, um, I guess it's a little wide open, but the question or comment that we get from the public has to do with do-overs, and more specifically, why do criminal defendants get a do-over when their attorney is deemed to have been found? I guess the phrase is that they didn't competently handle their case, but in other types of lawsuits, pretty much every other type of lawsuit, as far as I know, there may be some other sort of relief that they can get, but they can't get a do-over. What's that about?
In criminal court, if your attorney is found to have been ineffective, then you may be able to do your case over. But there are other issues too. If the district attorney did not follow the rules, and there are certain rules that the court deems as mandatory reversal. If there's an issue with regard to how the jury is picked, and there is racial bias in picking a jury, then there may be an automatic do over. There are two reasons. When you're dealing with every other area of law, there's a different standard of proof. And that means how much does the plaintiff party or the state have to prove? And in criminal court, it is the highest standard of proof. It is proof beyond a reasonable doubt. In civil cases, it is typically approximately 51%. And in other types of cases, it is clear and convincing evidence. And so those are different levels of proof. The courts have said we're unable to quantify it, but because there's a liberty interest at stake, meaning if you are found guilty in a criminal case, you very well may be going to jail or prison for up to the rest of your entire life. It's taken a little bit more seriously than other types of cases where if you win or lose, then we're dealing with money or property, but not your freedom.
Thank you so much for coming on. I feel like you gave some pretty comprehensive answers to all those questions. It's really appreciated.
Thank you very much for having me. I enjoyed our time together, and I want to thank the viewers. I think it is excellent that you guys are taking the time to research your candidates in all areas of the ballot, and I really appreciate this time to share a few things about me.